guys, it's Kathy. I hope you're doing well. Listen, we had such a crazy custody case during my live stream that I just didn't have time to play this. It was all about that. But this lady, I mean, I can't imagine what it's like to live in her shoes. I don't know if there's any laws she didn't break. Here we go. Let's go. Let's dive in. Buckle up.
Miss Clark would be okay. There she is now. All right. And who's representing the state?
Michael Costello for the state on Chantel Clark, Judge.
All right. Let's proceed.
Judge, this is case number 24 CR 1405, the state versus Chantel Clark. She's charged in this indictment with 1 count of aggravated assault and 1 count of felony obstruction of law enforcement officers. Judge, this is a case from May 8th of 2021 where the DeKalb Police Department responded to a domestic dispute call at 7. Upon arrival, officers meet the victim in this case, Julian Crumbley, Crumbley. Mr. Crumbley tells officers that his girlfriend, identified as the defendant, they're having an argument. It turns physical. And at some point, she hits him with a kitchen pan. There is a tussle. At one point, Miss Clark is alleged to have brought out a knife. There is a further tussle over that where Mr. Crumbley says that he needs to pin her wrists against a wall to prevent her from using the knife on him. Mr. Crumbley calls 911. He tries to lock Miss Clark in the bathroom to hold her until police arrive. And at some point, she swings her arm through the door while it's holding the knife. It does make contact with Mr. Crumbley. He does suffer a cut. It's not a serious cut, but there is a minor injury. When officers arrive, they separate the parties. Miss Clark does admit to officers that she picked up a knife, but she did it to defend herself against Mr. Crumbley because they've had past incidents with each other. And she also said that Mr. Crumbley had a knife as well, and they were both threatening each other. Due to the nature of this dispute, the responding officers had the special victims detectives come out. They do some further evaluation of the statements from everyone, and they make a decision that Miss Clark is the primary aggressor, the predominant aggressor, and we're going to arrest her. Miss Clark then locks herself in the apartment. Eventually, she's coaxed out, but when she's detained, she begins kicking at officers repeatedly. At one point, she kicks Officer Lawrence, and that causes her to fall down on the ground. And then she continues to resist arrest while she's been put in a patrol car. She is originally charged with battery, cruelty to children, and felony obstruction. When this case was presented to the grand jury in February, our office added the count of aggravated assault against Mr. Crumbley, which was never initially charged. Mr. Hudson was appointed as counsel prior to today, Judge. He did waive arraignment on March 27th of this year. I did provide Mr. Hudson with discovery prior to April 25th of 2024 when we were going to have a hearing for bond initially. I've since sent discovery to Miss Lynn. Miss Clark has been in custody since April 9th of this year on this grand jury arrest warrant, Judge. Candidly, I do not have contact with Mr. Crumbley. Our office has tried to reach out to him. He has not responded to us yet. But I do want to let the court know that there was a previous case where Miss Clark was arrested for battery against Mr. Crumbley back in, it's a subsequent case, Judge. It's a case in 2023 where Miss Clark is arrested for battery, family violence against Mr. Crumbley, despite there being a no contact order from this case in place. That case is currently pending in state court. She also has a September 2023 arrest for battery, family violence against her grandmother. That case has not been formally accused yet, but it's likely going to be in state court. Judge, before I get into the Ayala factors, I also want to let the court know about Miss Clark's involvement in a case that is still pending here in DeKalb County. It's a murder investigation. Miss Clark is alleged to be an eyewitness in a murder. That case was set to be tried in Division 2 earlier this year. Miss Clark was personally served by an investigator in our office. It's my understanding that when Miss Clark was served, she threw the subpoena back at the investigator. She subsequently failed to comply with the office. A material witness warrant was taken out prior to trial. Miss Clark was not able to be apprehended prior to trial. The state had to null pros the murder case because of her inability to cooperate.
Murderer
That
went
case
free.
has since been reindicted under 24 CR 1972. That's pending in Division 2. In the interim, Judge, Miss Clark has been held in contempt, was found to be in contempt of court by Judge Jackson under case number 24 CV 1766. That's from April 12th of this year. And she was sentenced to 10 days in jail due to her contempt. Also, Judge, we've been monitoring her jail calls, and there has been some concerning contact, not only with Julian Crumbly, where she has asked him to come to court and dismiss the charges, but she has made a lot of statements to people on jail calls about fleeing the state and going up to New York. So when Your Honor considers the Ayala factors and, the factors or the facts of the case for the indictment, and also her actions as it pertains to, her being a witness in this other case, the state has a lot of concerns that she's not coming back to court. I think that she is a high risk of flight due to her statements about leaving, about throwing a subpoena back at an investigator that's personally serving her for a case that's pending here in our jurisdiction. I think that she's a danger to the victim in this case, Mr. Crumbly. The facts on the indictment allege a very serious aggravated assault, that a knife is being brandished at somebody. There's a reoffense on Julian Crumbly in a case that's pending in state court. I think that her history and the facts of this case show that she's at risk of reoffending on Julian Crumbly. And I do think that she's a risk at intimidating, or not necessarily intimidating, but asking a witness to not come to court, given the statement that she makes to Mr. Crumbly on the jail call about coming to court to dismiss the charges. I'd request that Your Honor continue to hold her in no bond status. Now, I do understand that Miss Clark is pregnant. I'm sure Miss Lynn is going to bring that up in her argument today. And I understand that Your Honor may be moved to grant a bond in this case. If that is the case, Judge, I'd ask for a high bond in the amount of $200,000, that she have an ankle monitor affixed to her prior to her release, and that she be on house arrest, that she have no contact with Julian Crumbly, that she have no violent contact with law enforcement officers. And I'd also ask if Your Honor can put this as a provision in the bond order that, we'll give an exception for medical if she needs to attend, maternity visits. But if there's any other movement on her ankle monitor outside of medical or court appearances, that the state be notified as soon as possible.
All right. Thank you. Ms. Lynn.
Yes, Your Honor. Again, good afternoon. I have the honor of representing Ms. Chantel Clark in this matter. As you're aware, Judge, I was just appointed to this case. So I'm working off of the information I've been able to obtain within that limited amount of time. It's my understanding, Judge, that Ms. Clark initially was charged in May of 2021, May 8th of 2021, with battery, one count of child cruelty in the 3rd-degree misdemeanor, simple assault, aggravated assault, and obstruction. And at that time, I believe she was given a bond, Judge, and that she was able to post that bond, as the state just presented. As of February 20th of 2024, Ms. Clark was indicted by grand jury on an additional charge of aggravated assault, as the state just indicated, with Mr. Crumbly as the alleged victim, and also another count of obstruction. Judge, we are asking, in consideration of Ms. Clark's position, she is with child. She's 8 months along, Your Honor, and she has 4 other small children, ages 6, 4, 3, and 1, that the court either issue reasonable bond on the 2 new indicted charges, or in the alternative, apply the previous bond that she's already posted to the newly indicted charges. I wanted to speak to the facts briefly, Judge. I understand the state just laid out the general facts, but I wanted to highlight that upon law enforcement arriving on the day of the incident, that is correct that there were 2 different versions of the story being given between Ms. Clark and Mr. Crumbly. Mr. Crumbly did indicate that Ms. Clark was the primary aggressor. However, Ms. Clark intimated that Mr. Crumbly was the primary aggressor, that he had been physically abusive to her in the past, and that both her and Mr. Crumbly had a knife on the day of the incident, and she grabbed a knife in defense of herself based on his prior conduct. To my understanding, at that point, law enforcement did request that Mr. Crumbly remove some of his belongings from the residence, based on Mr. Crumbly's prior conduct with Ms. Clark. She did not agree with him re-entering the home.
Ms. Lynn, I'm not concerned about that. Those facts. I'm concerned about her ability to return back to court in light of those positions that the state has indicated. So the facts of the case are not the concern of the court. My intent is to grant a bond, but she needs to be on an ankle monitor, so that we can make sure she does not flee the jurisdiction in light of what she specifically said on jail calls. So I'll make the bond $5,000 bond, and she has to within. I'll give her well, I think most of the time when you do the ankle monitors, they try to set that up before you're released anyway. But she'll be connected to pretrial services. She'll contact them within 24 hours of her release. She'll be on an ankle monitor prior to her release. Can she make the $5,000 bond?
I believe she does have some resources, Your Honor.
Okay, so it'll be a $5,000 bond. The reason I'm making the bond so low because I'm gonna have her on an ankle monitor with the provisions that she can go to her medical appointments, and of course, if she has the baby during that time frame. So any other time, and I really don't mind after the baby is born if she happens to work or something of that nature, but in any it's work, home, medical, and anything outside of that is a problem. We need to know where she is at all times, pretty much. That's what I'm saying.
Yes, Your Honor. I would imagine she will need to take some time off of work. Beyond that, she's employed at Champion Wings Restaurant off of Redan and North Harrison.
Right. And along that, she has to, wherever she works, it needs to be somewhere kind of, stationary. She can't like do Uber or something like that. She needs to be somewhere where she can go somewhere 9 to 5, or, I don't really, not necessarily saying it's a 9 to 5, but it needs to be somewhere stationary so that there's not a lot of movement.
Yes, Your Honor. I will make that clear to her.
All right. Thank you, Mr. Costello. Can you prepare the order for the court?
Yes, and Judge, just before And Miss Lynn, can you send me a good residential address for Miss Clark and a good address for the place of employment?
Yes, I can put that in the chat.
Sounds good. Or you can email me.
All right.
Okay, sounds great.
Mhm.
Well,
Ms. Clark will be-
whoops.
Okay.
Well, there we go. So sorry, my son's playing Overwatch. He's very loud when he does that. Yeah, I don't. Crazy, crazy life. This was a couple years ago. I don't know who's the daddy of that baby. I wonder if it's Crumbly. I don't know. That was a couple years ago, so maybe they don't even know each other anymore. Although she's still contacting him. Hey, drop these charges. Don't show up for court. And they can't find him. So he's not going to show up for court. But the murder case is what has me the most interested about this. What does she know? Was she involved? I don't know. Okay, that's how rumors get started. I just planted a completely fake rumor. But yeah. Thanks for coming out, guys. I will see you tomorrow. Sorry about that. Bye.